Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. In days of old, when sailors used to go out on ships with big sails to sail across the ocean, every now and again they would hit a patch of the ocean where there was no wind, and they called this hitting the doldrums. I am certain that many creators, myself included, sometimes hit the doldrums with regard to what to make for content. But as the channel has become more popular, as we've picked up more subscribers and people have been much more willing to drop me an email about things they're curious about because they have curious minds, it has become much easier to do content here. And so I want to thank everybody who has done that. One of my subscribers asked me this question. A few days ago in the YSL trial, the state's witness, Bean, on the stand, remarked after nearly falling asleep, "Man, I'm so high right now, not even going to lie to you." Let's look at the clip.
You qualified it as the detectives and police, and I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. We're going to take a break soon. Hang in there.
So he then asks, is this an appellate issue? I think I understand why the defense teams didn't move to strike. They are in the middle of trying to discredit his testimony. Even though he hasn't answered anything on the stand, lots of "I don't recall." Let's watch.
Did you just hear us talking about this incident of the car careening into the side of the laundromat?
How you saying play something? I don't remember though.
And did you hear you explain that the case involving Mr. Dotson was totally dismissed?
I don't recall, sir.
And for you, the case involving the armed robbery or attempted armed robbery or the aggravated assault on Mr. Dotson was dismissed. You pled guilty under Alford to aggravated assault on the 3 police officers and fleeing and attempting to elude. True?
I don't remember.
And then I asked you, was Jeffrey Williams, performer known as Young Thug, involved in any way, directly or indirectly, with the events involving Mr. Dotson on September 11, 2013? And you said he was not involved in any way. Did you hear that?
I don't recall, sir.
Why would the judge not strike his testimony? He's visibly high and said so himself. Does this factor simply go to credibility? What if he were drunk and not high? This is supposed to be the state's witness. Would they ever be put in a position to strike their own witness's testimony? So let me answer a couple of questions before I talk about this generally. Is it potentially an appellate issue? Well, it could be. But usually this goes to weight and not admissibility. When someone has a problem or can't recall, it goes to both their credibility and to the weight that the jury can give their testimony. Is the state ever going to be in a position to strike their own testimony? Well, only if the testimony is unresponsive to their questions. If just because somebody's testimony, you don't like it, doesn't give you the right to strike the testimony. If you feel that the person is going down a route that they can't be brought back from, you simply stop. You know, it's like the old thing about digging a hole. The way to get out of a hole is to quit digging, so you quit digging. But let's take a look at these issues a little bit more generally. Now, whether a judge should allow a witness to testify if they're under the influence of drugs or alcohol depends on a bunch of different factors, including the relevance of the testimony and the credibility of the witness himself. So If they are speaking on something that is not directly relevant to an issue in the case, then it could easily be, the jury could easily be told to disregard the testimony as it pertains to some peripheral issue. But if it's relevant, even though the witness is impaired, again, it goes to the weight the jury can give that witness's testimony. Another thing is the degree of impairment. Now, it looked to me like he was pretty impaired, and the potential for prejudice to the other party is greatest when they can't get a straight answer or they can't get an effective answer out.
Did you hear me ask you about the jail recording that's now marked as Mr. Williams number 205 around the 11-minute mark, me playing it for you earlier in Mr. Investigator Martin's car, and then ask you about it, about they gave us a story to tell? Did you hear that?
I don't remember.
And your response was that you were going to be in a lot of trouble if the police wanted Jeffrey Williams in it. And that conversation occurred on September 11, 2013 at the hospital.
When the witness does not recall, the jury has the recording, they can hear it, and I would object to Mr. Steele's narrated version of the
That's the standard question. He can't remember it, so.
If someone testifies on direct that the car that went through the red light was red, and then on cross-examination they're asked, are you certain the car was red? And they say, well, I don't remember whether it was red or blue or green or whatever, but I believe I testified that it was red, so it must have been red. Well, now you have a basis to strike the testimony because it's internally inconsistent and it's non-responsive. So you have to be, alert to the possibility of what you can move to strike, as well as to the ability of the evidence itself to show something you may want to put forward. Now, he mentions in there, look, the defense isn't going to move to strike this guy because he's so high, he's bouncing off the ceiling. And that's true. But the issue then becomes, what if he says something that actually helps your case? Now the prosecution can come in and slap him around for being under the influence of drugs. The greater question might be, why was this guy actually arrested after his testimony? Because he came into court under the influence of drugs. Now here's another thing that could happen. The court could, on its own motion, order him held and charge him with contempt of court, because it does show contempt of court to come into the court in an inebriated or impaired condition as he did. Now, the judge also has to assess the degree of impairment. If a witness is severely intoxicated or under the influence to the extent that they can't communicate coherently or recall events accurately, their testimony may not be reliable or useful in the case. So, in that situation, the judge might very well strike all of the testimony on the basis that the witness was simply too impaired and that there is a danger of confusing or misleading the jury. Now, the prejudice issue is really important. Allowing a heavily intoxicated witness to talk about things that went on could potentially prejudice the defendants or even the state and cause the jury to essentially disregard all of their testimony, even that was originally designed to help the state. The judge has to consider whether the witness's impairment might unfairly influence the perception of their testimony, and on that basis, he could either prevent the testimony or stop the testimony from going forward. Competency is another issue. Witnesses have to be competent. They have to be able to understand the questions and provide coherent answers. And if they can't do that, then the judge does have the ability to essentially take them off the stand. Also, you have to protect the integrity of the trial. The judge's decision usually aims to protect the integrity of the trial process so that neither party is unfairly disadvantaged. If allowing an intoxicated witness to testify would undermine the fairness of the trial or the search for the truth, the judge can choose to exclude or limit their testimony or give a limiting instruction. For example, the judge might say, Mr. Bean's testimony here was clearly under the influence of some form of intoxicant. The jury should consider that when it considers his testimony. So he can limit the amount of damage that the witness can do. In many cases, if the witness is visibly intoxicated or impaired, the judge can decide to postpone their testimony until they're sober, hold them in a holding tank until they're sober, or do something else to provide reliable testimony. For example, if he's under the influence of something like heroin or fentanyl, you can order the sheriff to give him Narcan and reverse that narcotic. Alternatively, the judge may allow limited testimony, as we spoke about earlier. Each case is going to present unique circumstances, and it's the judge's job to figure out how badly the testimony hurts or helps each side. And of course, you have to depend on the lawyers to make objections and state things that they believe are important here. So if this guy gets up on the stand and he's clearly blitzed to the point where he can't know his own name, and he testifies and it hurts your case and you don't object, well, that's on you as the defense counsel. Now, again, if you intend to attack his credibility and his ability to recall when you do your argument at the end of the case, then it's a legitimate reason not to object to his testimony. Because one of the first things you can do when you get up to argue at the end of the case is stand up and say, now you remember, Mr. Bean, why did the state bring this witness to us? Why did he make you sit here and listen to a guy who couldn't recall anything and who admitted under oath on the stand of his own volition that he was higher than a kite? Why would the state put you through that? Do they not have respect for you? I mean, there's a lot of things you could do with that information and with that testimony. So in terms of the defense, it may be actually more valuable to have had the testimony come in. Well, that's what I have for you today. Hopefully you found this interesting and helpful. If you have any comments, leave them in the comments down below, or you can email me as this person did with this very good question. And often, if you will put up at the top video idea or video request or whatever, it makes it easier for me when I'm going through my emails. I mentioned the other day, I get about 1,300 emails from a lot of different sources every day. It's a very daunting stream of information to manage. And so if you put something up there that catches my attention, I'm much more likely to deal with it, and I appreciate all of the help you guys give me. If you have the opportunity today, do something kind. One of my subscribers yesterday told me that they were donating blood. Donating blood is a wonderful thing to do. One of my worst misadventures was donating blood, but it wasn't my fault, and it really wasn't the person drawing my blood's fault. The person I was donating the blood for was a neonate, and there is a chemical inside the blood called 2,3-diphosphoglycerase, or 2,3-DPG. And the 2,3-DPG tends to increase in volume in stored blood. It becomes more prevalent. I don't think anybody understands how that happens, but that's what happens. So if they're going to transfuse an infant with blood, what they want is fresh blood. It's like that scene from Little Shop of Horrors about, must be blood, must be fresh blood. You remember what I'm saying. At any rate, they used a 14-gauge needle, which is about the size of a roofing nail, to get that blood. Holy cow, that hurt. So it is a sacrifice to give blood, and it hurts, but you know what? It does save lives, and I do hope that you consider that as an option. And then, after you've done a kindness or done something nice for somebody, come on back to the beach and catch me at this place tomorrow, and we'll talk about something else interesting. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.